I start thanking you, and I mean that most sincerely. I thank you for coming out this afternoon, because what we're going to talk about is the most profound change in American jurisprudence in the entire history of the country. And it's gone largely unremarked, though now its consequences are so apparent that anyone who even thinks about it can hardly ignore it. And I want to start with a story. This is a story I heard from a lawyer by the name of Jim Rowe. The lawyer got it from a judge for whom he clerked. The judge got it from his grandmother. And the grandmother lived here on Beacon Hill. And the story is how she spent the winter of 1775-76, when the British held the city and the rebels held Dorchester Heights and Roxbury and Cambridge. Now, since that's not our topic, you only get a bit of the story. The rebels would not let firewood come into the city to make it hard for the British, and it made it hard for everyone who was stuck here. Interestingly enough, they let milk come in because they had young mothers and families, and they thought that was humanitarian. The story is a rather compelling story. She told it to her grandson, Oliver Wendell Holmes, Jr., who lived to see FDR inaugurated. He told it to Jim Rowe, his last law clerk, who told it to me, and others, I'm sure. But the point is, there's 4 overlapping lifetimes, and that's the entire history of the Republic. This is all an experiment. And in our experiment of government, the American jury system is dying. It is dying faster in the federal courts than it is in the state courts, and it's dying faster on the civil side than on the criminal. And in rather conclusory terms, because we don't have all that much time, I want simply to sketch some of the indicia that ought convince you that it is truly dying, suggest some of the consequences of it vanishing from the scene, and then argue candidly one thing that we might do, we might consider anyway, doing to deal with that. First of all, the facts. And my comments are based on the federal courts now, and I'm not criticizing anyone. In the federal courts today, 1% of civil cases are tried to a jury. 2% get tried, but only half of them are tried to a jury. 1% out of 100 cases filed. Now, I'm not arguing that all cases should go to trial. System would go tilt if that happened, and that's never been the case. It's never. I've been at the bar now 35 years, 45 years. 45 years at the bar, 34 years a judge. It's never been more than 10%, but now it's 1%. On the criminal side, it's 3%. In Massachusetts, we double those. About 2% of our cases, civil cases, go to trial, and about 6% of our criminal cases go to trial. But how can we call ourselves trial courts when trials have such a minuscule portion of what in fact we do? 2 other points. One comes from Judith Resnick. You all ought to know who Judith Resnick is. In my mind, she's a professor at Yale and one of the 2 leading proceduralists of our time. I would say the other is Arthur Miller of Wright and Miller. Now, this past fall, she was on a panel, along with Arthur Miller, at the Association of American Law Schools in New Orleans. And her speech, I boil it down, I wasn't there, but at least 4 different people have told me, her speech was to people who in our law schools teach civil procedure. And apparently she got pointing her finger at them and saying, "You people are teaching a dead subject, dead as Latin. Your subject is gone." And it was echoed by our chair as we were introduced. That's one of the leading proceduralists of our time. And now something directly to lawyers. And I have been at it for a while. On the civil side, because trials are, in terms of your work, trials are so few and far between. I don't think there aren't great trial lawyers at the Massachusetts bar. There are and always have been, and they're not all the old ones. But because trials are rare, fewer and fewer lawyers have a feel for juries. And tragically, I see them buying into this myth that juries are unpredictable, erratic, go with the flashiest lawyer, those things that are simply untrue. I have the sense, and I think I'm close enough to it to know, that they're wonderful at the pretrial. All the reasons why we shouldn't go to trial, why there ought to be summary judgment, or no, dismiss it now, Twombly and Iqbal, and I won't go on. But when all of that's cleared away, and we're going to put the 12 people in the box, they start saying to their clients, well, this is really uncertain. It's really sort of a crapshoot. And it's not a crapshoot. And if you wonder whether it's dying, take a look at the military commissions. This fellow Khalid Sheikh Mohammed, I understand, the papers say, I know nothing about the case. Papers say he's the mastermind of 9/11. Constitution says, you don't need the Bill of Rights for this. This is in Article 3. The trial of all crimes shall be by jury. I thought that was a crime. Now, what about the consequences? I suggest to you the consequences that we don't really know, but here's where we're going. The consequences are to our democracy, to our polity itself, consequences to accuracy, consequences to our belief in fact-finding, and ultimately, consequences to judicial independence. First, democracy. Always remember, and this is not an argument that you ought to try every case to a jury. This is not CLE. You make your tactical choices. This is not an argument against settlement. Most cases should settle. They truly should. Lincoln was right. Most should settle. But if you're really doing your job for your client, some of them should go to trial. And when you're trying a case, always understand that what this is, what the American jury really is one of our 2 contributions worldwide to the whole concept of jurisprudence. We use juries theoretically for more different issues than any other country in the history of the world. We will commit the issues to a jury. And that's like a little special election. That's what it is. We're talking, the feds can't really whine about budget problems, but if sequestration hits, we're at least thinking about it. And so people say, well, we'll shut down once a week, or something like that. Well, no, we won't. We're not going to shut down once a week. Well, we don't have the money. Well, we'll call them in without money. That's what we did in the early days of the Republic, because people who have a right to trial by jury have a right, and those juries have a right to sit, to decide the people's business. It's democracy. So what are the consequences of just taking that democracy away? Say, no, we'll let juries do it. Judges do it. One of the consequences I submit to you is accuracy. Now, I'm intensely proud of being a judge. That's been my professional life. But all the social scientists tell us these days, actually, this doesn't come as a vast surprise to me, but they're discovering as though something's new, that we are all governed by our unknown biases. We don't think we're biased, but the truth is we are all biased. Well, I always thought we were. And the issue is, how do you counter that bias? Well, John Paul Sullivan on the Superior Court taught me this. He, as part of his charge, used to tell the jury that they ought acknowledge their biases. And the idea that we had 12 of them was so their biases canceled each other out. And I believe that as an article of faith. We also know from the sociologists that the best thing to counter our inherent biases, I'm not talking redneck now, I'm talking biases that I'll be very personal, I don't know I have, is what's known as a vivid experience. And you see, that's the experience of the courtroom. That's what the philosophy, that's what first-year law, I learned it. The reason we have the adversary system is that it is the best way to keep a human being from jumping to a conclusion about something he does not know based upon the things he does know. So it is. Going out on the bench and actually seeing the people improves the accuracy of the process as nothing else that humankind has come up with. So I'm fond of saying this to my law clerks. It's all very well for us to sit back there in our lovely chambers, and there's one of them, and I have some of my other wonderful clerks here, brilliant people. That's all very nice as we talk back and forth and they tell me their brilliant insights about things. And I respect and love it. But that's not the same thing as going out on the bench and listening to someone argue their heart out and looking at the client sit next to them. Frank Ford said it right. He said this to Austin Jones, the famous clerk. He said, "Austin, you have to go out on the bench and listen to the bastards. They might just have something." You see, that's the vivid experience. They might just have something. Now, the other consequence is to fact-finding. Jurors, that's their job, and we call them to their duty of fact-finding. And most every judge will tell you, I've actually done some experiments trying to confirm this, that judges all uniformly believe that juries get it right. And the longer I'm privileged to serve, the more I absolutely adhere to that. Juries get it right. But you know, an entire generation of judges, and I am one, has been treated to a disparagement, an official disparagement of fact-finding. You know that for 17 years in the federal courts, we sentenced offenders unconstitutionally under that oxymoron, mandatory guidelines. And mandatory guidelines, which actually drove the sentence, did not come from fact-finding. It came from what the attorneys told you and told the probation officer. And we engaged in this sophistry that, well, by a fair preponderance, it was so much drugs. Fair preponderance is a concept that has to do with evidence. We didn't take evidence about how much drugs it was. For 17 years, on the crucial issue of what you would sentence an offender, we did it based on a mishmash of what the lawyers had to say. We didn't much care about what the actual facts. Oh, we cared. We talked about it. but there wasn't any evidence. Now, when you get away from fact-finding, Brock Hornby, in a brilliant article called The Business of the United States Courts, points out that most judges today spend most of their time back in chambers, and he says they're engaged in what's called fact sorting. I've got no idea what fact sorting is. Apparently he's thinking about how we read affidavits. You know affidavits, the Potemkin villages of modern American litigation. All lawyer-painted flash and no interior architecture. Do you know they have companies now that write expert reports for the experts? Companies make businesses doing that. The more you get away from the trial and the actual testing of the evidence in an adversary process, and I suggest to you before real people, the more corruption is likely to work in. And we're headed for drone strike justice. You feed all your data in, and after a week or a month or 2 months, out comes an opinion. You never see from whence it comes. It may cripple you, but it's done by somebody. Judge signs their name to it. Now, lastly, and this is really a turf issue, I guess, I'll be very candid. This business of getting away from juries, thinking that we can operate the system without the people, it is the greatest threat to judicial independence that exists in America today. And that is the other great contribution that the United States has made to the jurisprudence of the world. It's not the adversary system. Many countries have a highly developed adversary system. It's not an independent constitutional court. While we have been very successful on that, the federal constitution drawn from the Massachusetts Constitution, that, Montesquieu wrote about that. The philosophers had that in mind long before there was an America. No. We have given the world a truly democratic jury system, and then we have imbued at the trial, we're the only country in the world to do this. Think about this. At the trial level, we have imbued the judicial officers with the power to declare statutes constitutional or unconstitutional. No country in the history of the world does that. None. And why do we do it in America, and why is it accepted in our society? It's accepted because, you see, it's the only way the jury system can work. When Marshall said in Marbury, it is emphatically the province of the judicial department to declare what the law is, yes, he was a Chief Justice of the Supreme Court, but he rode circuit. He understood that in order to actually have a trial and find the facts, you had to teach the jury what the law was. Imagine a system where we had all the rights that we have now, every single right. We have them all. Oh, but you have to go to Washington and petition for certiorari to get a court to hear you. That isn't how America has worked. The Constitution is as close as a fan pier. Nothing's ever settled under the Constitution. You go down there and you can get, if you get the ear of a judge, you can say that your right needs to be redressed. Only in America do we have that. And the reason we have it is because we commit the facts to juries, and trial judges have to teach juries what the law is. If you did away with that, you could still have trial courts, but you could, as they did in the Anti-Terrorism Effective Death Penalty Act, you could say, well, no declaring anything unconstitutional or mucking around with that decision unless it is clearly violative of the law as declared by the Supreme Court of the United States. You could pass a law that says that. take away that first instance right to adjudicate constitutionality. Well, my time's almost up, but I'm not going to stop. Give me a few more minutes. What is one thing that we can do? And I'm limiting myself just to the federal courts. One of the reasons, one of the flaws, one of the faults is that the federal institutional judiciary, the Judicial Conference of the United States, we federal judges, lifetime appointees, don't seem much concerned about juries. The strategic plan for the federal courts, the most recent statement of how we ought to operate, never mentions the word trial. Never. Mentions juries twice. One mention says you want to feed them well, take care of them well. That, I suppose, is good. And we have slipped into what I call the administrative model of judging, and it's explicated in the handout. The administrative model of judging, and this is the intellectual model that holds sway in all the courts, federal courts throughout the land, that it is the role of the judge to move the business, to get case resolution. And of course it is. Most cases should settle. I don't differ with that, but that's not the goal. The other model, less well thought of, fewer judges, fewer and fewer believe in it today, is the trial model. That the best thing, the way we adjudicate matters, is through trial. Of course most things should settle. Of course we should urge them to settle. But the goal, where we're going here, if you come into court, we're going to a trial. And you see, that's disfavored in the administrative model because trials are slow. Trials do take time because we're engaged in individual fact-finding. And if you can get a resolution without trial, that's favored. You know the difference, and I'll be glib about it, but you know the truth whereof I speak, and you can tell right away when you come before a judge. The administrative model judge is thinking to himself, how can I get rid of this case? The trial model judge is thinking to himself, what's the verdict slip going to look like? That is a different set of skills. It may be overlapping, but it's different. I'm going to end up and tell another story. This is an edgy story, but I don't hesitate to tell it. I try to stay on top of various law reviews, and I ran across this. This is by a young lawyer, and he's in the patent field, and he thinks there ought to be a specialized patent court. And I'll even use his name. It's unfair because he's not here, but he did publish, so I can use his name. David P. Cohn. Mr. Cohn's about 5 years at the bar, and he writes well. And here's what he says in his law review about juries. If you wonder that this is really an issue, here's what's out there in the law reviews. You know, juries bring little knowledge and judgment to deciding issues compared to judges, while also being accompanied by their own unique limitations. Juries undercut the desired goal of predictability. Juries are less predictable than judges since they lack the accountability and other constraints that judges operate under. The jury system poses a lower level of transparency than judicial decisions. Many characteristics of juries limit their ability to dispense informed and objective justice, especially when compared to judges. The typical juror has only a high school education. The problem is obvious. Whereas the typical juror must deal with legal concepts that may be largely foreign to his or her life experience. Let's see, juries drawn from the general population, as all juries are, will tend to have innate biases towards those they identify with, usually meaning smaller parties and individuals. Some might think this is a good thing, but then he says, On the opposite token, the wealthier side will usually have the option of hiring more persuasive and talented legal counsel. I've got a different view of it, and I'll end up by telling you my view. You know, in Newtown, only one of those teachers was cornered in a courtroom. The other 5 put their bodies in front of the children that were in their charge. And they died shielding those children with their bodies. And we say, aren't they heroines? And of course they are. But, you know, they didn't go to school that morning expecting to be heroines. They're average Americans called to their duty. Go back to 9/11. Everybody who got out of the Twin Towers, everybody who could get out of the Twin Towers, got out, and they ran for it. And hundreds of firefighters ran in. That was their job. They didn't come to work that morning expecting that. They were called to their duty, and they went in there and died by the hundreds. Or this story is a case I tried now in '87. As a domestic terrorist. He's on a rest area on Route 95 going south, and he's exchanging shots with a state trooper and the trooper's crouched behind his cruiser, and he's shooting back, and the terrorist who has a pistol in his hand is standing, and in comes a truck driver with a big 18-wheeler, and his headlights pick up this guy with a gun in his hand shooting. Now, you could go to the left of him and motor right on out of that rest area. No. The trucker goes between the shooter and the state trooper, and once he's got his truck in there, he jackknifes the cab trying to run the guy down. He didn't expect that when he was hauling south on Route 95. Now, next Monday, I will pick a jury. And I will walk out there, and I will look at those school teachers and firefighters and truck drivers, and I suppose that Mr. Cohn here, he doesn't think they're fit to rule. I think they are the very essence of American democracy. I think they are the purest form of democracy that humankind has ever known. And you see, it's not important what Mr. Cohn thinks. It's not important what I think. It's important what you think. And I tell you, Reagan got it right. He said this. He said, you know, whatever we may say, all our freedoms are not our inherent rights. They come to us from others by way of inheritance. And they are always within one generation of being extinct. They must be fought for and defended in every generation, for they come but once to a people. Now, if you believe in the American jury system, go and make it so.
Well, first of all, let me recognize many of my former colleagues, and one of my brand new colleagues, Judge Paul Wilson, who was sworn in 2 weeks after I was, and I think he's been sent here to make sure I'm honest. I have tried innumerable trials, jury trials, before Judge Young, and if it is possible, it is more nerve-wracking to sit next to him than it is to be in front of him, I have to say. Maybe it's just the strength of his voice is that much stronger.
I was a cub master.
That's what it was. I was a federal prosecutor for 20 years. And during the course of that time, I learned over and over again, when you're making an argument in front of a jury, when you're making an argument in front of a judge, you lead with your strongest evidence first and follow it quickly with your most problematic piece of evidence. And I'm going to follow that practice right here with you. I'm going to start by telling you I am an associate justice on the Superior Court, one of the most scholarly, inspiring, well-qualified, creative, and well-regarded state courts in our nation, and I'm proud to be there. The problematic part of it, from your vantage point, is I've only been there since August. So, and I told Judge Young, and he knew that very well when he invited me to do this. So I have some very pedestrian observations of my experience in state court, and also some sort of visceral observations and a few substantive ones to throw in, which I think are not nearly as rhetorically interesting as Judge Young's, but I think might be worth sharing. Having left Fan Pier in August to go over to Pemberton Square, the first thing you notice is the difference in the trappings between state court and federal court. It's fairly remarkable, and now I'm sitting in Lowell, and it's even more remarkable. There is a significant, palpable difference in the level of richness between the two courts. That is not true when it comes to the nature of the people who run the place. The judges, the clerks, the jurors, the probation officers are every bit as qualified and every bit as caring as the ones I left behind in federal court. And I have been struck by that these people in many ways labor against much more difficult odds to do their job, and they do it really well. Having not nearly the resources or the pay. They've all been sort of shrunk in their pay over the past decade. I also noticed that the state court appears to operate more as a department store as opposed to a boutique. The jurisdiction of the state courts obviously makes it that way. It's a very broad and general jurisdiction, whereas federal court is a much more narrow jurisdiction. But you can't help but get the feeling when you're in state court that you're in a department store and you can go anywhere you want to find what you need, whereas you need a personal shopper in the federal court to get you through the system. You need somebody who knows federal court and knows federal procedure. It's a much more exacting practice, it's a narrower practice, and people tend to be more experienced to practice there. The courtrooms in Pemberton Square and in Lowell, where there's the two places I've sat, are open from 9 in the morning until 1 when everybody leaves for lunch, and then they're open again from 2 to 4. The courtrooms during those hours are packed. They are completely packed. The clerks work in the courtrooms as opposed to in offices somewhere else in the courthouse. They have desks in the courtroom, and when there is business to be done, people walk into the courtroom, walk up to the clerk, and they begin to do their business. It's run a little bit like the New York Stock Exchange. It took me a little while to get used to the fact that while I was doing my business on the bench, the clerk was doing a huge amount of business right down below me, and you know that happens all day long, every day. You get much more of a sense that there is sort of active business being conducted in the courtrooms every day, all day. Since I started in August, I have presided over 8 jury trials and 1 criminal trial, the 1 criminal trial that ended yesterday. I have been I never shared that poor law review article author's view of juries. I've always loved juries as a lawyer. I always found them to be my salvation, particularly when I was scared to death of the judge. I could communicate with the jury because the jury, I knew in the end, was really going to make the decision, not the judge. And so I have found that to be true. These jurors are always reluctant in the beginning, but they grow to love their duty. And I've seen that in my 9 experiences talking to juries afterwards. Anecdotally, I have learned that the pressure on state courts to manage the dockets has increased significantly. And I would say that that goes back 10 to 20 years. There have been new case management techniques. I see some senior litigators here in the audience, and I'm sure that you know better than I what has happened in the state courts, but there are tracking orders now that track cases the day they're filed until the day they're finished, and everybody from the Chief Justice down to the clerk and then to the lawyer is forced to really focus on what is the next event in this case. What are we doing next and why? And I think it's sort of like the kick the dog phenomenon. Chief Justice Rouse gets on touch with all of the Rajas, and the Rajas get in touch with all of the judges, and the judges pressure the clerks, and the clerks pressure the lawyers. And before you know it, everybody is actually really focusing on the future in a way that I think perhaps did not happen before. I know that now cases go to trial typically within 2 years, whereas it used to be between 4 and 5. It's very unusual now to try a case that's much older than 2 years. There are fewer jury trials on both the criminal and the civil side in the Commonwealth, and I'll come back to that, but there's no question that there is not only fewer trials, there are fewer filings in many cases. Another change, I think, that has sped up and focused on achieving some level of disposition in state courts is that most courts now are split, so that they try cases in the morning and they resolve motions and other business in the afternoon, and the federal court does that as well. It used to be in state court that if you had a trial, the trial went from 9 to 4, everything else got shoved to the side and it would be rescheduled for some time down the road. The problem with not knowing when things are going to happen means that there's no planning, there's no pressure. All of us know that every one of us operates better and faster when there are deadlines. It's just a fact of human life. And when there are deadlines, things tend to move. And I think moving focuses everyone on figuring out, crystallizing the question. Why are we doing this? What do we expect to achieve? How best to achieve it? It's like trying a case by knowing the verdict slip ahead of time. I can't agree with that more. Now, in reading, I did some reading in preparation for this since I didn't have much else to base my comments on. I did sort of have some different responses or reactions than Judge Young has. First of all, I think that if you compare a courtroom to a playground, okay, if you think of the courtroom as sort of the adult version of dispute resolution that often happens on the playground for children, the fewer fights there are in the playground, the better. And maybe the fewer fights there are in a courtroom, the better. And maybe it is better that we have a class of incredibly well skilled and effectively trained lawyers that maybe are resolving disputes or preventing disputes in a healthy fashion. And so maybe the courtroom, like playground brawl, isn't necessarily what we want. We want the threat of the courtroom so that people know that when things go awry, they will go to a courtroom. If you compare a courtroom to an operating room, if you have fewer surgeries, maybe that's because they're more healthier patients. That doesn't mean that surgeons don't have to keep their skills sharp and their instruments sharp, as all lawyers must. We all must be prepared to preside over trials or try cases. But if you look at the legal system sort of like the health system, do we want so many people on the operating room table or in a courtroom? I don't know as a public policy matter what the answer to that is. I'm just raising it as an observation that courtrooms may not necessarily be a sign of health. They may be a sign that things have gone very badly. In the contract drafting procedure, maybe contracts are being drafted better. Maybe there are less people driving drunk. And maybe there are these things happening that make the courtroom less of a requirement. I think that's one thing that I have thought about quite a bit, because I tend to think that we lawyers are trained for the courtroom. We are trained to love a trial, which is the apex of our skills. And I think quite rightly that it is the apex of the sort of the constitutional democracy that we have in this country. I'm not sure that more jury trials is a sign of better health. That's just what I want to think about. So I sort of close with that. And in 3 years, if you ask me back, I might have more to say.